Please be seated.
Nothing has actually changed other than all of the microphones have been checked. So one has to proceed if it doesn't work. Thank you. Mr. Owen, I was asking you about the standards that are already applied through legislation or contracts, and you've spoken primarily of schools, the Catholic schools, which have to comply with various other standards, and they won't be required to comply with the standards that the company ultimately sets. That's right?
No, they won't have to duplicate the process of establishing compliance. They will still have to comply with those standards, and those standards will be, by incorporation, part of the overall standards system.
No, I understand that, but the standards that the company will set will be in addition to or the same as and therefore already covered by the school standards? In harmony with and then in addition to areas that are not covered by the government-mandated standards. So that, I take it's the same in relation to the Catholic welfare arm that provides out-of-home care and other youth-based services? Yes. And it's too early to tell whether the standards set by the company will significantly extend those or not? Correct. It's the case, isn't it, that most dioceses and perhaps orders engagement with children is through schools and the out-of-home care work? Yes. So that to the extent that the standards either replicate or don't go further than the existing legislative or contractual standards, the engagement that will be covered by the standards of the company, relatively small group of children? Yes. And those will be children who engage with the parish through parish and presbytery activities? That would be one, yes. And to the extent that the parish priest engages with children in schools, other than, of course, as a teacher? Yes. Any other? There may be organisations, the younger arms of groups like Catholic Youth, for example. It would extend to those as well. The Royal Commission has heard from a number of those agencies, as you know, and their evidence is that nearly all of their activities are funded by Commonwealth or state governments, and with that funding comes conditions. You're conscious of that? Yes. So to the extent that there's youth arm, as you describe it, activities, and it's funded, it will have its own sets of conditions? It would do, yes. Thank you. Now, can we turn to the constitution of your company, which is Appendix C or Annexure C to your submission? It begins with 0099 at the top for the ringtail reference. And if we can turn first to the objects and powers, this is at 5.1 on page 4. Do you have that in front of you? I do. And you can see that's promote the safety of, prevent abuse or misconduct and respond to allegations. Yes. So that covers the complaint handling process as well. Then secondly, entering into contractual arrangements. Yes. That's the matter you've referred to before. Correct. By that means or mechanism, the authorities will have compliance checks. Correct. And then education and training and auditing and compliance. Yes. Just in relation to D, auditing compliance, is that proposed to be done by an external auditor? I would imagine so. I think that's the thinking, that Catholic Professional Standards Limited would accredit external audit agencies, and it would be the external audit agencies that would conduct the audits. Thank you. Now, turning over to 5.3, there's reference there to the reports, that is the compliance reports, being made public unless the board resolves that the information has the potential to cause harm to church contacts.
Yes.
Can you help us with contacts?
Church contacts is a defined term in the Constitution, and it relates to, in this context, effectively children and vulnerable adults who come into contact with the church, who are either in the care of the church or who have some association with the church. In other words, it's the identification of the people to whom the protective mechanism is addressed.
The clause doesn't refer to redacting or otherwise limiting the publication to protect those people, but I take it that would be anticipated.
Yes, by nature, I'm in favour of principles rather than prescription. I don't like clauses in agreements that go on for pages and pages.
However, you'd appreciate that it's extremely broad to say has the potential to cause harm to church contacts.
I do.
When indeed most of the work to be done will be with vulnerable people.
Yes, I accept that.
The second one is inaccurate. The third is likely to cause confusion or to mislead the public. Again, very broad.
It is.
And then could endanger public safety.
Yes.
Now, taking all of these four together, could be argued that they provide very large reasons for not publishing.
Yes, that's one way of interpreting it, but I can only go on the intention that's behind this. The teeth in this system is public reporting.
And that's why I take you to these clauses. Mr Owen, I understand that, and that's clear from what you've said earlier. However, this clause seems to provide extraordinary power to the board not to publish.
Yes, it does. It does. But the intention is that public reporting will be the norm.
Mr Owen, it may be that public confidence in this body won't be enhanced, though, by a clause that is so broad.
Well, it's in its embryonic stage, Your Honour, and this, I suppose, is an easy answer. But there's a lot yet to be worked out. And if the board, for example, or, as you say, through expressions of public concern, perhaps coming from what happens today, perhaps as the mechanism work themselves out, if the Constitution needs to be changed, then there is a mechanism for doing that.
Well, the question is who judges the need for the change. That's the issue. I mean, the Church proffers this as the, as it were, current position. And if, as you accept, there's such a broad discretion in the board not to publish, then people might think that this will never change. There won't be publication.
That is not the intention. It never was the intention. Throughout the discussions in which I've been involved, it was made clear that this was the mechanism by which accountability would be held into the system. The drafting is there. I can't take it any further than that, Your Honour.
Then, in terms of membership, at the bottom of that page, there's reference to the members being the Australian Episcopal Conference, which is effectively the Catholic religious. I'm sorry.
No, that's the Australian.
That's the Bishops' Conference, and then B is the Catholic religious.
Yes.
And then C is any other entity that is admitted as a member. Is there intended there to be anyone else identified?
Well, the logical one would be the umbrella body that's just recently been established for the ministerial public juridic persons. So that's I think there are 11 or 12 of them that have assumed the missions of various religious congregations in health and education in particular. So that would be one body that could come in under the any others.
That body has indicated an indication to come in yet or not?
No, they've been involved in discussions, but they're like Catholic Professional Standards Limited itself. They're still feeling their way.
Thank you. Now, if we can come to clause 35, this is the clause that regulates the number of directors. And you see it's between 3 and 9 directors, and the nomination committee shall take into account considerations in clause 39, to which I'll come, and the member representatives shall by resolution determine whether a candidate shall become a director. So that's the case that effectively the archbishops and the provincials determine who's a director. Is that how we read that?
Correct. It's the members. The members act through their members' representatives. So that's the efficiency part. But it will be the members' representatives who will make the appointment of the directors.
And shortly that means the archbishops and the provincials?
Yes.
Thank you. Now, 36.4, there's reference to when electing a director, member representatives should consider whether the board is comprised of an appropriate range of skills. Do you see that?
Yes.
And then the considerations by the nomination committee are in clause 39. And the first is a commitment to an understanding of the philosophy and work of the company.
Yes.
And that can best be understood with reference to the objects of the company.
Correct.
Secondly, exemplifies the company's vision, mission and core values.
Yes.
What's the source of that? Nomination committee?
I would imagine most organisations these days develop mission statements, and I think that's what that's referring to, that the company will develop a mission statement, and that will then be one of the guiding principles for use by the nominations committee.
And this will be, in effect, directors that will be appointed when vacancies arise rather than the initial directors. Is that right?
Yes.
And then the third one is demonstrates a commitment to an understanding of the philosophy and works of the church.
Yes.
Effectively a committed Catholic.
No, not at all. Could I give you an example?
Certainly.
I've been involved with a large number of Catholic educational establishments, secondary schools in particular. In my time, the most effective deputy principal was a person who was totally committed to the philosophy and works of the church, and he was a Baptist.
So a religious person, just not of the Catholic faith.
In that particular example, I can't think of any others that you would say were agnostic, but there may have been.
You understand, looking at the considerations by the nomination committee in A, B and C, it is almost inevitable to assume that the directors will be committed Catholics.
I don't think that's right.
No?
No, I don't.
And that's by reference to what you've given as an example in C of somebody who could be committed to the work of the church but of a different faith.
Yes, I'd take it a little bit further than that. I think that an organisation like this, to fulfil its role, will need a broader range of thinking than simply people who are committed Catholics.
Although that's an essential consideration, according to the clause.
Being a committed Catholic?
Being committed to and understanding the philosophy and works of the church.
That's different to being a committed Catholic. People can, I think, have a commitment to the sorts of values and ideals that are central to the gospel values of the Catholic Church, and yet not be Catholics.
Well, I don't quite understand that, Mr. Owen, but unless you want to explain it further, we can move beyond that.
Well, I don't think I can.
Thank you. And then coming over to the reserve powers that you referred to earlier, the effect of the reserve powers is that the approval of the archbishops and provincials are necessary before any of these matters become effective.
Correct.
And the first one is the adoption or amendment of any professional standard.
Yes.
Now, that's one of the key objects of the company, is to set those standards.
Yes.
Secondly, approval of a strategic plan, business plan, annual budget. which is fairly standard.
Yes.
Thirdly, a decision to terminate membership.
I have a problem with that.
Yes.
Because the directors don't have a power to terminate membership.
Well, no, because the membership are those who appoint the board.
I think that's a decision to terminate membership of the company.
So these powers are the approval of the member representative shall be required as a prerequisite to any decision of the board becoming effective. So you're assuming that the board in this case would say to the membership, we want to terminate one of you. And
what I'm saying is I think it's, I haven't used this phrase for a long time, it is inelegantly drafted. I don't think it should be there at all because the board has no power to terminate membership of the company.
And then D is taking any disciplinary action against a Catholic entity concerning non-compliance with professional standards. Now that's perhaps the second key aspect of the objects of the board, to set the standards and then audit compliance and take action. Is that right?
Yes.
So effectively what's reserved to the members, the key work of the company, isn't it?
Again, can I say, reading this closely over the last few days, I would make the same comment. I think it's inelegantly drafted. I don't think it is actually a reserved power. And I say that because the directors don't have a power to discipline.
Is there any reference in the Constitution to disciplining?
No.
The reference is only to auditing compliance.
And publication.
So the Constitution, other than the reserve power, doesn't provide for what to do if a bishop doesn't comply with the standard.
That's right. I'm using the word teeth because I'm trying to avoid the use of the word sanction. But the teeth is publication. There are no other disciplinary functions.
And the effect of this in the reserve powers is nullified by the fact that the board doesn't have any of the powers to give effect to D. Is that what you're saying?
Yes. I could proffer a view as to why it might be there, if that would help the commissioners.
Certainly.
The working is the disciplinary action against a Catholic entity. There is no contractual relationship between a Catholic entity and the Catholic Professional Standards Limited. It may be that what is there is to reinforce the view that the only body that could discipline a Catholic entity within the structures of canon law would be a bishop. Now, those disciplinary powers are limited. It would be for others to tell you what they are or what they may be. But I think it may be there out of an abundance of caution to indicate that it is not the role of CPS to discipline Catholic entities. But in my view, again, the drafting is not particularly happy because I don't think that there is a power to discipline and therefore it can't be a reserve power.
So in the event that there wasn't compliance with the standards by a bishop, then would you see that canon law provisions, whatever they might be, would have a part to play in relation to the bishop rather than this constitution?
Correct.
And whether or not there's a role in canon law for that, for the moment, we just don't know.
I don't know. No. Sorry, I can't explain it.
No. Thank you. Now, the members appoint the first directors.
Yes.
And subsequent directors after a vacancy arises. Is that still the members?
Yes.
You'll know that under the Irish scheme that Ms Devlin described the other day, after the first vacancies arise, the chair of the board appoints the directors.
I heard Ms Devlin say that. I can only assume that she's talking about practice that has developed because the constitution of the Irish company, Articles 32 and 34, indicate that it's exactly the same system as the Australian model, which is that the members appoint the directors. So I can only assume she's talking about a practice that has developed.
And that practice could or could not develop here?
My memory from reading Irish constitution is they don't have a nominations committee. They don't have provision for a nominations committee.
No, that's right.
So to that extent, our system is more structured. So that practice might develop, but if you're going to comply strictly with the constitution, you would need to go through and get a recommendation from the nominations committee.
Do you have a view on whether that's a preferable approach or not?
Me personally?
Yes.
I think boards should be self-renewing. My preference would be to follow a practice similar to the Irish model, but that's not what the Constitution says.
No, but the Constitution could be amended.
The Constitution could be amended, yes.
Is there any provision for the directors to have a stated duration of directorship?
I think there is. I'm not sure where it is, but I think it's a 3-year term.
Thank you. Now, in terms of the training of directors, you'll have heard there's been a deal of evidence about the necessity to train those who have roles in relation to child protection more broadly, and that includes directors. Is there any proposal in relation to that?
Are you talking about directors of the state professional standards officers or directors of this company?
Directors of this company.
I would be very surprised if the directors didn't involve themselves in training, because this is a very specialised area. Child protection and also the protection of vulnerable adults is a very specialised area, and it's the way of the corporate inverted commas world these days that directors do involve themselves in training.
So modern governance would tell us that the directors should
Correct.
be trained.
Yes.
Who appoints the staff?
The directors.
With the approval of the members?
There's nothing in the Constitution that says that. I notice that that's the case in the Irish Constitution, that it's actually I think the sponsoring body
yes.
that approves the appointment of the CEO and senior staff. But under this Constitution, it would be the standard conventional system where it's the directors, not the members, that appoint the CEO and senior staff, or all staff.
How is the appointment of the CEO progressing?
As I understand it, there is a headhunter who has been engaged, and the process of finding candidates and shortlisting is reasonably well advanced, but I haven't had an update for some weeks.
Is there a budget that's been set?
That's outside my knowledge. I don't know.
You'll recall from Ms Devlin's evidence that the resources were provided by the bishops and provincials based on how much money they had, effectively?
Yes.
Is it expected that a similar approach will happen here?
As far as I'm aware, the funding model, as between the members, has not been finalised.
During the course of the last 2 weeks, there's been much mention of governance and the like, and there has been some evidence that without the necessary resources, initiatives, which could include this, either perform inadequately or fail because they just don't have enough money. Has anything been put in place that you're aware of here to make sure that doesn't happen?
No, and the same situation applies. In all of the discussions in which I've been involved, there's a recognition that this body must be properly resourced. It's recognised that that was one of the problems with the National Committee for Professional Standards. It must be resourced, and you are quite right. If it's not, it will fail.
Who's responsible for making sure it is, as opposed to providing the funds?
It comes back to the Australian Catholic Bishops' Conference and Catholic Religious Australia.
Now, you've indicated that the teeth of the company is in the publication of the audits.
Yes.
That's right. Is it proposed to publish any other information in addition to the audits?
As I understand it, there will be the annual reports, This company, again, as I understand it, will have its statutory reporting obligations. It's also, I think, either is or is to be registered under the Charities and Not-for-Profits legislation, so that carries with it some reporting functions. It would publish an annual report in much the same way as Ms Devlin's described and are in the papers for the Irish model.
Is it anticipated that that annual report will include statistics on numbers and outcomes of complaints at all?
That's my understanding that it would. I can't be specific, but yes, I think certainly there will be statistical information, and I'm assuming that it will. Part of that statistical information will go to the outcomes and handling of complaints.
So there'll need to be some arrangement in relation to the redress scheme, however it ultimately looks, so that that information will be conveyed via a reporting mechanism, a public reporting mechanism?
Yes, because we are going to be operating in at least two compensatory and complaints handling systems, yes.
Is it proposed that outcomes for priests and religious, the subject of complaints and or redress, be published?
Individuals?
Yes.
I don't know. No, I don't know that.
The United States system, which I'm sure you're aware of, its annual report, which is in the tender documents, contains pages and pages of statistics. Have you had a look at those?
I have, yes.
Is it something that the council can answer, not now, but perhaps by the end of this week, by reference to those pages and pages of statistics, what it is intended that be published by using that as a benchmark?
I doubt it, Ms Finesse, because that would be in a way binding the directors. That's a decision for the directors to make. I'm quite happy to give you some information as to what the thinking of the council has been, but I can't take it that one step further and bind the directors.
No, my question was the intention of the council in respect of it. So I think from what you've just said, you could provide that.
Yes.
Thank you. Perhaps if I could ask whether that's possible to be done by Thursday?
I'm having a nod from my right, yes.
It's probably all you need, Mr Owen, is a nod from your right. Thank you. Now, as you would know, in terms of good governance, there is usually a process of review of the work of a company or the process to be followed by a company. You accept that?
I do.
And there is in respect of this company and its work?
I think it's specifically provided for.
Thank you. And you'd expect that?
Absolutely.
And in terms of the standards which are to be set, equally it would be expected that within a reasonable period of time they would be reviewed?
Yes.
Much as Ms Devlin provided?
Correct.
Now, one of the issues that she specifically raised was in relation to data sharing.
Yes.
And the difficulties, obviously working within their particular legal framework, that have arisen in relation to data sharing between different dioceses and the company. What do you think will happen in that area with this company?
I think that under our privacy laws, I think there will be similar problems. Some of them may be able to be cured by the contractual arrangements that are entered into, but others, there may need to be some sort of legislative assistance. I haven't developed my thinking because I haven't actually needed to address that particular issue, but the sorts of problems to which Ms Devlin referred, I think will also occur here because of our privacy laws.
No, I don't think there's a constitutional problem in quite the same way that she described it there, but certainly there are a number of laws here as well as contractual provisions.
That's right, but that's why I say that some of that may be able to be cured by the contractual arrangement through the Memorandum of Understanding.
But it would be an issue that would need to be on the members or board's table very early on, wouldn't it?
I'm sure it will be, because it's fundamental.
Well, it's also fundamental to publishing statistics.
Correct. Yeah.
You will also know from Ms Devlin's evidence that she has a safeguarding review process. It's perhaps more my language than hers. You understand what I mean?
Yes.
Where members can sign up to be part of this process where the board engages external people to review what they're doing in that area.
Are you talking about what she referred to as the National Case Management?
Well, I was referring to the safeguarding review, which was somewhat different, I thought. The case management was more in relation to individual cases, was it not?
Yes.
And the review was more broadly about policies and processes. Anything that the council has thought of in relation to the broader reviews, or do you think the compliance process will cover that?
I think it will. I think that would probably be part of the compliance process. The use of external accredited auditors is one thing, but I think there may well be a need to get other assistance from outside to ensure that what is being done is in accordance not only with what the company thinks are appropriate standards, but which general experience dictates likewise.
Mm-hmm. Well, that's in relation to the creation of the standards, and I'll come to that. This is more looking at whether or not the work of a, let's say, diocese as a whole is complying with the terms of the standards, but also the principles.
I'm sorry, that is what I was referring to.
Thank you. Now, the case management committee that she referred to is a body, again, that a member can join that provides information on more individual cases. Is that your understanding?
Yes.
Is that something the council's considered?
Not until we've heard, well, from my perspective, not until we've heard Ms Devlin's evidence. So far as I'm concerned, that has a lot to recommend it. But again, I can't bind the directors. The Constitution would be broad enough under its education and training function to provide for that sort of a mechanism. That's something that the directors will be apprised of.
That is an issue that would relate closely, I suggest, with the developing of the complaint handling standards and also how it fits in with the redress processes.
Yes, and particularly if this develops in the way that church authorities can adopt different methods of complaint handling. That would I think have added significance.
Complying with the standard, but nevertheless the practice differing between dioceses, although it is said that they comply with the standards or principles.
Yeah, that's right.
That would leave you in the situation you're in today, firstly in relation to Melbourne Response standing outside, but secondly in relation to inconsistent application of Towards Healing.
Yes, that has to be avoided.
How can it be avoided under this company structure?
Because the standards will give guidance as to principles to which whatever the model is that's being used by a particular church authority, that must comply with those particular standards. Those standards will be backed by principles. They'll be at the level of principles and policies, but I would imagine that they will also be supplemented by strong guidance notes, so that the actual operation of the adopted model will have to be within the confines that are developed within that particular assistance mechanisms.
It sounds like a description of Towards Healing.
No, it's not. Because Towards Healing, as I understand the criticism, the tying together aspect of Towards Healing was never really properly implemented. And so that's why the inconsistencies developed. If you had more direct standards, policies and guidance, then the likelihood of these inconsistent approaches developing would be lessened. You're never going to be able to eliminate that unless you've got a single standard approach. And even then, I suppose, it depends on the way individuals approach them, the individual person approaches them. But without that strong guidance and something tying it all together, there is a danger of inconsistency arising again, just as it has in towards healing.
But the council, certainly to the extent that it has influence in this respect, acknowledges the inconsistencies in towards healing and the reason for reducing or eliminating that inconsistency, and that approach will be told to, or at least influence, the work of the company.
It will certainly be told to, and I have told to the company, and I would hope it influences the work of the company.
Thank you. Your Honour, I'm about to move on to a different topic.
Would you be much longer with these gentlemen
A
today?
little bit.
A little bit. All right, we'll take a short adjournment.